Hi, my name is Steve Murphy, and this is the Insider Exclusive. Welcome to our show. Today, we're going to be taking an inside look at one of America's and Southern California's premier law firms, Girardi and Keese. Stay tuned.
We represent people, ordinary folks who've been harmed by corporations, and we've had the ability to be successful for them.
It's a mistake to not somehow communicate to a court that some of your arguments are stronger than others. To be a great advocate, you've got to be able to put yourself in the mind of the judge.
Congress did something by initiating something called PDUFA. What that did was make the FDA and the pharmaceutical companies lie in bed together somewhat, because the pharmaceutical companies actually write a check to pay the FDA to review their initial drug application.
As soon as you have politics and economics becoming the driving forces behind the decisions that are made by the FDA, we're in a world of hurt.
And my first guest, Girardi and Keese, is the actual founder, one of the founders, Tom Girardi. Welcome to the show.
Hey, thank you. Thanks for having us.
You're known as a king of class action lawsuits. You're also known as the billionaire gentleman of personal injury lawsuits. What exactly does that mean?
I think primarily we've been so lucky. We represent people, ordinary folks who've been harmed by corporations, and we've had the ability to be successful for them, to level the playing field.
Right. There are a lot of critics of plaintiff law firms, as you well know. They usually come in the color of Republicans, correct? And they often say that firms like your own, are just going after these major corporations. But one of the reasons that I even do these shows is because you actually help the little guy, don't you?
That's all we help. And the fact of the matter is, if you look at some of the stuff that corporate America does, without law firms like ours,
yes,
the little guy didn't have a chance. They can throw a law firm to defend these cases, 500 guys, 700 guys. The paper's enormous. And unless you have the ability to fight back, the little guy gets totally crushed.
Right.
And you know what? In these cases, if you were to look, matter of fact, I would bring one of the most conservative people down to our office and start going through them. Do you think this is a viable case? Do you think this is right? Do you think this is right? Honest to God, Steve, 99% of those cases, everybody would agree with.
Yeah, and let me ask you this question. When I say you're the king of the class action lawsuit, and I mean that sincerely, bottom line is, what makes your firm and what makes you more successful than other people trying these cases?
Well, in part, done it a long time.
Yes.
42 years.
But you're real good at it.
Things have been really great. And then success breeds on success. A lot of times the thing that makes you mostly successful is because of the quality of the cases you have.
Right. So
that then you can be involved in a case against an energy company. We're very successful against Sempra Energy and El Paso, matter of fact, for the people of the state of California. And by having a law firm like ours, dedicated people, work their buns off, and then to have great opportunities to take on the Sempras of the world, that's what makes it fun.
What you're best known for, probably because of the movie Erin Brockovich, is that case where residents in Hinckley, California, were actually diagnosed with certain types of cancers. Was that it?
Oh yeah, that was I got to tell you about this case though, just in terms of how lucky you get. PG&E had these cooling towers to cool the gas before it goes into the generators. And the gas is too hot when it comes in on the El Paso line, so they cascade water over the pipes. And then the water was corroding the pipes, so they would put chromium in the water, which is an anti-corrosive.
They're protecting the pipes.
Protecting the pipes. Now the bad part about chromium, it's an insidious carcinogen. 1 pound of chromium does all the damage that 50,000 pounds of benzene would do.
No kidding.
Yeah, it's very insidious. Then when the water was used, they would just dump it on the ground, and then it poisoned the the water wells, and all these people were using that water for everything, to wash in, to bathe in, to drink,
right.
mother's milk, etc.
There was, but one of the things that I think where you get angry and anybody else would get angry about them doing this is there came a point in time when they became aware, right?
Oh, there's no question.
They became aware that they were poisoning the water, that they were causing all these irreparable, harmful, medical problems, and they sought to cover it up, didn't they?
No question. Matter of fact.
And that's what makes you angry, isn't it?
That's what it's all about.
Yeah, that's what it's all about. So when did that time come?
I'd like to say it was my great legal work that did it. Mm-hmm. But really it was somebody we never know. We got a plain envelope one day of 2 memos. Mm-hmm. One memo from the foreman at Hinckley to the head office saying the chromium levels are now far exceed the limits. Should we give the people bottled water?
Yes.
And the reply from one of the heads of the company says, the less said about this, the better.
Right.
It could lead to liability problems.
Mm-hmm.
Obviously, armed with that, we then knew we had more than just an oops. Oh my gosh, the company didn't realize there was chromium, etc.
Right.
Now we knew that the company knew exactly what the problem was, what the potential was.
In the course of a lawsuit against them, is there ever a point in time when you go to them and said, we've got irrefutable evidence to show that you guys are guilty? Or do you just wait to spring it on them later on?
It depends who you're dealing with.
Okay.
You know what I mean? Sometimes you would come forward with good evidence like this, and the other side would simply start to try to attack it and attack the person that wrote it and do all those sorts of things. Mm-hmm. Sometimes in dealing with law firms that you have a great deal of trust and so forth in, you'll say, hey, listen, I got this stuff.
Right.
And that changes the price of poker.
Some of the other big cases you've been involved with is the Ford rollover cases, right?
Sure.
I remember reading verdicts, something like $460 million and that sort of thing. They were that large, weren't they?
Well, they were large. Yeah, we didn't collect all that.
Yeah.
But
it was the jury was sending a message, and the message is, you made a product that was not sufficiently, designed to protect people, and then you tried to cover it up. Correct?
Generally, in all these cases, there's an element of cover-up.
Yes.
I'm amazed. Email is the curse of a bad defendant.
Yes.
Because that's
Bill Gates found that out.
It never goes away, man. It lives forever.
Yeah.
Exactly. And some of the great emails that we've gotten, we have one case. We have a toxic case going out in Simi. Mm-hmm. I won't mention the company, but there's a memo there where the guy says, I don't think we ought to do any further testing because this is a hazard to the people.
Yes.
And he is then told, we're going to continue to test. If we kill a few people, that's what our law firm is for. They're the best law firm honest to God.
This is in the memo?
This is in the memo. I got it. I mean, I should send it to you someday.
Well, I often think there's been memos, especially with the automobile manufacturers, that said something to the effect that if we kill a few people, it's cheaper to pay them off over a long period of time than redesign the vehicle to be a better safety standard.
That has happened. Grimshaw was that way.
Yeah.
But, there's benefit of all this, too, of these cases.
Yes.
You see changes taking place.
Mm-hmm.
In the environmental stuff, now we tried the Lockheed worker cases that were using all this toxic stuff.
There was the Skunk Works case?
The Skunk Works case, right. Tried that case 5 times, over and over again of various workers.
Yes.
However, if you look at those same products now, there are huge warnings on them. Mm-hmm. This causes cancer. This causes neurological problems.
It would be safe to say that without firms like yours, and particularly yours, because you're one of the most successful, that the safety of the consumer would be at great risk because businesses, I hate to say this, but businesses just sometimes don't give a damn, do they?
They cut corners.
Yeah.
They really do. And matter of fact, you see all these products that are defective.
Yeah.
They knew that. You know what I mean?
Right.
They knew that when they were putting it out. They knew those little dolls that the head would pop off and the child would choke.
Yes.
They knew that. So it is, I think, firms like ours, I think we help a lot.
I'm glad we can take this inside look at your firm. We're going to have some more of your partners on the firm, and I look forward to having you back on the show again.
Hey, thank you, Steve.
Thank you.
Nice to see you.
In And my next guest of Girardi and Keese is Howard Miller. Welcome to the show.
Thank you, Steve. It's really
Howard,
great to be here.
I understand you handle a lot of the appellate work at your firm and intellectual property.
That's what I do. I do appellate work and intellectual property, patent litigation especially, which has become a very important area. It's really exploded because of the importance of technology in the economy.
So give us an example of some of the cases that you're handling. You don't have to mention the names, or one that you've handled in patent litigation.
Well, one now that I'm handling involves technology that is in cellular handsets for locating people when they dial 911. The Federal Communications Commission has mandated that all cell phone manufacturers include a technology that when anyone dials 911 on the cell phone, the location is known. That's easy when you've got a physical handset, but with a cellular phone you could be any place. And our clients patented years ago, it's a great human interest story. Clients are an emergency room physician and his high school buddy who has a PhD in electrical engineering. When he was an ER physician, he couldn't find someone who had called in on a cell phone, went to his buddy, said, we got to solve this problem. They patented technologies years ago for providing location, and now we are representing them against major cell phone manufacturers who we believe have infringed the patents that they got.
How did they get that exactly? Like the Freedom of Information Act, or they went to the PTO, Patent and Trademark Office, and got the information and just decided to copy it and produce it?
Well, sometimes, I don't think people do that so much, but what they do is they come out with technologies, they find out about it. Sometimes they do it innocently, they invent things that aren't aware. Sometimes they do it willfully. Big companies especially often say, well, what's our risk? Who's going to represent these people if we go and infringe? So there's a lot of risk analysis, a lot of power exerted. And these technologies turn out to be very, very valuable.
Now, for all the would-be inventors out there who are looking at, you know, or they've invented something and they know that a big company, this happens a lot in America, it happens everywhere. You know, a big company says, okay, we're just going to steal this little guy's invention, we're going to produce it because we know somewhere down the road we're going to settle with him, right?
Right. That's what they think.
What kind of approach are you having with the big cellular companies who have copied or basically used or infringing on this?
Well, talking about it generally, we're in a different, in a unique position, and people who come to us and who we agree to represent are in a unique position because we handle everything on a contingency. And the major problem with patent litigation is how expensive it is. If you're a small inventor and you have to pay lawyers by the hour, and there's a huge demand for patent and intellectual property litigators, you need a ton of money to even bring the lawsuit. For cases that we take, like all our cases, we handle on a contingency, and so the client doesn't have to bear that risk and cost of going forward, and the firms that are on the other side know that about us. I mean, they know that when we get in a case, we're in to stay, and so it evens the odds in terms of coming out okay.
Give our audience an example of the cost of bringing one of these cases.
We took over another case where a client finally just had spent so much money they basically had to either drop the case or find someone like us, which they did, where they had already spent $8 million over a period of 18 months and gotten nowhere. It's easy to, in terms of lawyer time, to spend $5, $8, $10, $12 million on a patent case.
How do you evaluate cases? I mean, there's a lot of people watching this show. There's a lot of people feel that their patents were infringed upon. If they come to your firm, how do you guys evaluate it?
We look at the patents. We do our own due diligence. We engage our own experts to do the evaluation. We make an evaluation of the client, who is very important, the client's credibility. The reason I talked about the background of the cell phone case is what a great human interest story. Emergency room physician, human need, his high school buddy. But we really do due diligence on the technology. If the technology is solid, we really don't care who the defendants are.
Girardi and Keese is known as a great trial firm. You guys you're going to go the extra mile, you're going to take it to court, and the other side knows that. What makes a good trial attorney?
What makes a good trial attorney, first of all, is the willingness to get into battle, to fight. But in the end, it's also experience that's a large part of it. There are naturals, but you need the experience. Of the 23 lawyers in our firm, I think over half are members of the American Board of Trial Advocates, which is meaning you have a significant amount of trial experience to do that. At any given time, we probably have 4 or 5 trials going on in the office. That's what we do. And the single most important thing in a trial lawyer is to have the experience to handle what's been done. Not just to be the natural. We hire a lot of naturals. Give them a lot of experience. We take cases, as a matter of fact, so that people can get the training. We deliberately take smaller cases So the younger lawyers, we have young lawyers in our firm that have been there 3 years that have had 8, 10 jury trials. That just doesn't happen in other places.
Right.
Because we train them that way. And it's the training and the background and the experience.
What are some of the cases you're working on now?
I'm working on the patent case I mentioned, another
Yes.
patent case involving a cancer technology, handling appeals on some toxic tort cases. I do the appeals also in a lot of the other areas.
Toxic tort cases, like, for example, an Aaron Brockovich kind of a
An Aaron
case.
Brockovich case, we have a case involving now an appeal going to be argued in the Supreme Court of California sometime this year probably, involving expert testimony in a toxic tort case. So for me it's very interesting. I get to do the trials on the intellectual property side,
Right.
but then when it comes to appellate work, I really do appellate work for all the areas of the firm.
When you go to an appellate court, no more jury there.
That's right.
So you're really talking to experienced jurists who have, seen and heard everything, and generally they knock down the award that's happening. What do they base that on?
Well, the most important thing and the most difficult thing to teach younger lawyers is how important it is, especially in appellate work, to be candid with the appellate court. Some lawyers, they go in and they argue everything the same way. Strong points, weak points, they're wrong on nothing.
Yeah.
It's a mistake to not somehow communicate to a court that some of your arguments are stronger than others, and that you
And how do you say that? How would you say that?
You would say, Your Honor, what we're really focusing on is this particular point because we understand that in evaluating point 2, there are other factors that are involved.
Yes.
There are all sorts of ways to communicate it. You've got to be able to be a great advocate. You've got to be able to put yourself in the mind of the judge.
Yes.
And say to yourself, if I
Excellent.
were the judge, how would I, it's like Stanislavski and the training for acting.
For acting, yeah.
You've got to be able to be the observer and the participant at the same time. And if you can put yourself in the mind of the judge and understand how the judge thinks of the case, then you know how to talk to the judge about
That's
it.
probably why Abraham Lincoln was such a good lawyer, right?
Abraham Lincoln was as great a lawyer as ever lived in the United States, whether he'd ever been president or not.
Yes. Well, I've enjoyed having you on the show. We're going to have some other partners on the firm, and thank you for joining us. We'll have you back.
Thank you, Steve. Thanks so much for having me.
And my next partner is Jim O'Callahan. Welcome to the show.
Thanks for having me.
I understand that you actually have a little bit of a specialty, pharmaceutical drug litigation at the firm, right?
That's correct.
How did you get involved with that?
Well, I started out doing a lot of medical malpractice cases.
Okay.
And as a result of my exposure to a lot of the medicine, physiology, anatomy, human biology.
You become a doctor.
Well, not quite,
Okay.
as doctors are free to point out to me, and frequently do. But as a result of that, I developed some expertise in the areas that it's really important to know about in pharmaceutical litigation, particularly in areas of what causes the problems that drugs are sometimes associated with. So that was really the basis of my involvement.
Right. We're going to get into a few of those drugs in a minute, but when, you being so close to seeing so many pharmaceutical drugs having problems, when you buy drugs, pharmaceutical drugs, you got to be extra careful. I mean, is there any company out there that produces a product that you can feel safe with?
I don't want to talk about any particular company,
Yes.
but I think it's fair to say that the majority of drugs on the market are safe, and
Yes.
particularly the generic drugs, which are have been tested over time, which are drugs that are have a long history of use, and there's a lot of history and understanding of how they operate. But it's over the past 10 or 15 years, there's been a change, I think, in the way that drugs are tested,
Yes.
in the way that they're marketed, and in the way that drug companies focus more on marketing product rather than on saving lives.
Right.
That's been a significant change, I think, within our experience as consumers of drugs. And certainly it's a massively profitable business for the drug companies, and they are not reluctant to put a drug out there without doing the type of testing that they did, say, 20 or 30 years ago. And I think that's been the biggest change.
Kind of in a way, you're doing the FDA's job, aren't you? I mean, let's comment about the FDA, because the FDA has let a lot of these drugs go to market, and then come back later and say, well, you know, maybe we should have looked at it a little bit better, right?
That's exactly what's been going on, and I think that reflects the fact that the drug companies now outnumber the FDA in terms of the personnel. And for example, at the FDA, there's a ratio of 20 people who are in the process of getting approval for a drug, as opposed to one person who's actually looking after trying to see whether or not the drug has any adverse effects.
The scientific data, right?
The scientific data. Now,
but the scientific data is submitted by the pharmaceutical company based on the controlled test that they perform, correct?
right.
So it's kind of like they're showing their best light forward and not really bringing out some of the other negative tests.
That's very much a part of what's been going on, and also you have the phenomenon of burying adverse information amongst a lot of other data. And those are the two biggest problems, I think, that the FDA faces in trying to do its job.
Let me ask you a question. They haven't been able to get a commissioner in place that has the staying power to protect consumers. What the hell is the commissioner doing there right now?
Well, the current commissioner is coming under a lot of criticism because he's inherited something which you've probably heard about, the RU 286 situation, and that's something that
that's a political issue.
It's a political issue, and that's the worst thing that can happen to our FDA. As soon as you have politics and economics becoming the driving forces behind the decisions that are made by the FDA, we're in a world of hurt.
You know, you brought up a lot of good information, and we're going to have a separate show just on this because this relates to all Americans. And, you know, this is important because there's, you know, lawyers like yourself really bring it to our attention about what we should or shouldn't be using. So thank you for being on the show. We're going to have you back on a regular show, which is going to be a normal American pharmaceutical drug litigation show, and we can talk more in depth about that, okay?
That'd be great.
Thank you very much, Dan.
Thanks.
And my next guest, another partner at Girardi and Keese, Paul Sizemore.
Thank you
for
Steve.
the show.
Appreciate it. Thank you for having me here.
You're very much involved with drug litigation too, aren't you?
I really am. That's my primary focus at Girardi and Keese.
We had one of your other partners, Jim O'Callahan, in here talking about it. But one question I didn't ask him, which I'm going to ask you: why pharmaceutical drug litigation? Of all the practices out there, why that?
Well, I don't think anybody chooses to be in pharmaceutical litigation, Steve. It really came about that I was involved in products liability and medical device litigation. Then we had this rather a panacea or Pandora's box that opened up, which was Vioxx. And it's not something that we jumped into immediately, but when we started hearing the stories about individuals that have been hurt by this drug, especially family members, it really evokes an emotion in you enough to, you know, jump into something like this.
Do you have a family member or a friend that has been injured as a result of a product or, you know, pharmaceutical drug?
Steve, it's interesting you asked me that. I don't have one, a blood relative, but the first trial that I had, the young lady whose husband died called me her son by the end of that trial, and we still talk today. And I think that just shows what can happen when you spend time with these folks and how you can become emotionally attached to these people that you're trying to help.
What other kind of pharmaceutical drug cases are you handling?
Well, I've been out of town this week on Bextra and Celebrex, and we're also handling some Avandia cases. I don't know if you've heard about that.
It's some new news, isn't it?
It really is. It's a case that we've been hearing a lot about through the FDA, and is kind of a warning signal perhaps with this drug, akin to what we see with the COX-2 inhibitor drugs. But it's only of late that the FDA has issued what we call a public health advisory on this drug.
I understand there was a physician, a well-known physician in Illinois, was it?
That's right.
Yeah, who came out with a report based on information he got from the internet.
That's right.
And said, wait a minute, there's too many cases here that are going haywire. We need to take another look at this. And one of the organizations that brings this to light is the New England Journal of Medicine,
right,
which is a well-respected organization.
One of the best in the world.
It seems that your firm and others like it, and the New England Journal of Medicine is doing the job of the FDA.
Well,
I mean, yes or no, is that right?
I
You're not
think
going to
that's
offend
probably
anybody at the FDA.
probably fair.
Yeah.
The FDA has a lot of good doctors, experts that try to do the best that they can, Steve.
Yes.
But I think most people don't understand the FDA's role here.
Mm-hmm.
They don't take drugs. They don't take a sample that the pharmaceutical company brings in and test it for safety.
Yes.
They don't do any testing. All they do is rely upon a stack of materials that the company gives
I
them.
got to stop you here. They rely on a stack of material that are submitted by the company that wants it approved, correct?
Exactly.
So this is a biased, I mean, truthfully, it's a biased research report, isn't it?
There's a lot of financial interest by the pharmaceutical company involved in it.
This is crazy.
Well, let me take you back one step, too.
Yes.
Back in the late 80s, we had a horrible epidemic, the AIDS epidemic, that hit the U.S. and the whole world.
Yes.
And there were a lot of drugs out there that needed to be expressly expedited to get out to the public to help people. And the Congress did something by initiating something called PDUFA, the Prescription Drug User Fee Act. You have to count it out, or you almost forget the acronym on that one. But what that did was make the FDA and the pharmaceutical companies lie in bed together somewhat, because the pharmaceutical companies actually write a check to pay the FDA to review their initial drug application. So not only does the FDA not do any actual testing on the drug, with this stack of documents about the safety of the drug comes a big check from the pharmaceutical company.
I would like to believe that there are some pharmaceutical companies out there that have in their uppermost priority the safety of the consumer. Are there?
Absolutely. Absolutely there are. And I don't think you'll hear anybody, even plaintiff's attorneys, you know, who some people cast stones at, say that all pharmaceutical companies sit around trying to hurt people. That's not true. But there's a lot of money invested here, a lot of shareholder interest, a lot of personal financial interest, and sometimes people can become somewhat blinded.
By the way, I wanted to give out your website so people can get more information. Would you kindly give that out?
Sure. It's Girardi and Keese is the name of the law firm. And
Keese is K-E-E-S-E.
I always spell it out. Girardikeese.
And what is your phone number down at the firm?
213-977-0211.
I want to emphasize, a plaintiff lawyer is someone that if you have a problem, you go to you guys, they don't have to pay you any money, right?
That's exactly right.
You take a case based on the merit.
We like to call ourselves consumer lawyers too, or consumer advocates, but there's no problem with a plaintiff's attorney.
Right.
What we do is someone who's been injured or had a family member that's been injured that don't necessarily have the economic fortitude or assets like a corporation.
Yes.
They can come to us, we'll review the case, and if we believe it has substantial merit, then we will agree to go forward and forward all the costs of the litigation. And if there's a recovery, we recover those costs.
Well, it was very good having you on the show.
Well, I enjoyed it very much.
We're going to have you back again. Thank you.
I enjoyed it very much. Thank you for having me.
Okay. Thanks for watching our show. We'll be back next week, and you can watch more of our shows at www.insiderexclusive.com. Thanks again.